So if I may, yeah, so we've been actively working both with Colorado but also Washington. I think some of the biggest challenges for us is understanding how to approach the issue of safety with a substance that nobody actually has any solid science about what is and is not a safe level, either in a food or in a human being, because there hasn't been any research, as I'm sure you're aware, on cannabis. And so we're hoping to learn, and have been learning actually from our colleagues' experience in terms of serving sizes and concentrations that are allowable, that sort of information. Each state has a slightly different approach, but there are some consistencies throughout, and that's where we're trying to glean our best information from, so we can be sure that what we're creating is something that allows the program to continue, but also protects safety.
In addition to underscoring what Undersecretary Houston and Dr. Smith said, I think something that I've learned through working with the various states, as well as going on tours, it really highlighted to me the need to strike a fine balance between my mandate, which is consumer protection and the regulation of this industry, but also compliance and making sure that we don't over-regulate in our zeal to get things right. That, and my colleagues said it very well as well, requires education. I'm seeking to be very knowledgeable in this, but there are people much smarter than I that you will hear from, that I seek counsel from. We seek counsel from each other, and through that process, it's going to help guide our hand in the promulgation of regulations. I would say that is one of the most important things through this process, is striking that fine balance and communication.
Well, and I think that makes it even more important, the chair's recommendation, which I strongly second, that we have a regular review, and you incorporate a sunset review process into what you are doing, perhaps, or on the side of making it a short period of time as well, because it'll allow to see just how well you're reaching that balance, which is everything we regulate. We have to reach that balance. So thank you. I appreciate it. I encourage you to keep looking at what other states are doing so we're not starting from scratch. Thank you.
And Mr. Wood.
Thank you. I'll have some general questions here, but we'll see where we go with this. First of all, it's obvious that there's much to do and much to learn and not a lot of time to do it. I think that, Mr. Kidani, your comments about the potential for over-regulation very early on could create some unintended consequences, like lack of compliance, which is something we desperately don't want to happen. You also mentioned, and I'll ask how you consider, how you might consider advisory committees and things. And I myself went to Colorado on my own dime to try to understand, meeting some of these issues myself, meeting with various levels of agency staff and governor staff on this. So one of the things that came out of that, which is what I would encourage you to consider, if you have not already, is using ad hoc committees, using additional committees, not just a single advisory committee, because there is a tremendous amount of expertise available in the industry that unless you do that, you will miss it, and there will be potentially, I believe, unintended consequences. I'm very encouraged by hearing from CDFA that you're looking at small businesses and small farmers and trying to create pathways that are not necessarily so difficult and onerous to get past. I assume that I shouldn't assume anything. It's government after all. I hope that that communication is at the top of your list, and I would love to, as we get updates on this, to see how you're going to communicate, because this is a challenging. This is an industry that will be challenging to communicate with. They haven't operated in our system at all. And so as we seek to get compliance, how we communicate that, whether it's going to be workshops, updates, how you actually do that, I would love to see updates on that going forward. I think it's going to be absolutely critical. Other states, obviously, learning from the other states is going to be important. All of you have mentioned stakeholders, and I would encourage you to look at the industry as stakeholders. And I didn't hear it from all of you, but I think that there is tremendous amount of expertise there, and I would love to get updates on how you actually engage with industry there. It was interesting comments about there isn't a lot of cannabis research. And you're absolutely right, Dr. Smith. How do we break down some of the silos? Because one of the impediments towards cannabis research has been the lack of research funding, which is a big part of what challenges universities are having because, quite frankly, federal government controls a lot of that research funding. So how are we going to get the research that we actually need to get you the information you need to help us regulate?
That's an interesting question and a difficult one. You're right. Without the federal government engaging, it's very difficult to do any kind of large-scale work. One of the things that I've been discussing with my colleagues in other states, but also internally within the department, is what sort of surveillance do we want to put in place? So, in other words, while we're not going to be doing experiments in the typical way we think of, but what we can do is watch for say presentations to the emergency room and try and making sure that we are getting as much information as we can that can help us try to understand what are the situations, who are the individuals, what are the products that are most associated with negative health outcomes. And that's how we do much of what we do in public health, is that kind of surveillance. So that's something that we've begun to think about as well. Job one, obviously, is getting this act up and running and getting the regulations written. But then as it matures a little bit, making sure that we're not missing opportunities to get information from what's actually happening.
Well, even that public health data is not easy to get.
No, it's not.
And so do you anticipate that there will be opportunities, and are you looking to collaborate with the federal government, or is that a dead issue at this point?
As far as I know, the federal government does not engage in any way in cannabis research at this time.
So, and it's similar hard science too, because that's sorely lacking. There, because you did talk about science research. So, how do you see that going forward?
In the short term, I'm not sure that there are, short of sort of billionaire philanthropists who want to individually support research, it's going to be very difficult to do that on any scale. What we can be doing, though, is we can be crafting the questions that we would ask, because to get the biggest bang for the buck in research, you really have to ask the right questions. And what we don't have a lot of information on that, for me, is foundational in terms of the safety of humans, is what is the impact on the human physiology, and at what level does that become risk outweighs benefit? And so that's what goes into deciding what's a safe amount of any, particularly an edible product, far more so than a combustible product, because with the edible products, the challenge is that people don't get the effect they expect to get right away, and as a consequence are more likely then to ingest more and more of the product, and that can have negative consequences. So trying to understand what are the behaviors that are potentially risky, so that we can communicate well with the general public as well as to how to take advantage of this product in the safest possible way.
Okay, great. Thank you. Thank you.
Thank you to our panel. I just have one final comment, I guess. I wanted to say I really felt the approach of having phases for DCA was very wise, and it's such an enormous topic that you're talking about. I wanted to touch on the information technology, the computer system. For all of the departments, we know this tends to be a pitfall for the state. And so I think all my colleagues would agree with me that, we have a great opportunity here to do an IT system that's going to be very functional and hopefully effective as well. And just one final question, and I guess it's to Mr. Kadani, kind of coming off of Mr. Wood's question there about safety. What is your take on the potential for training, or the need for training in medical and patient care as we move forward with regulations?
Madam Chair, thank you for that question. Very good question, and it's relevant across almost all of my licensing population. The question of training, as the fields evolve, as technology improves, et cetera, training is very relevant. So generally, I would say training is absolutely vital. Training of what and how is yet to be determined until we start promulgating regulations, having a clear understanding of what we're regulating, how we're going to regulate it, how specific these regs are going to be, what's going to be required, and then the gap between the regulations and the population will point a very clear light on where that training should fill in. The method by which is yet to be determined, but very good question, and is something that we eye across DCA. I'm sure my colleagues to my left do the same thing in their jurisdiction as well. Mm-hmm. Thank you for that.
I think that I, with that question, really wanted to kind of refocus our attention again on the fact that this is medical marijuana use that we're talking about with the passage of this legislation and with these regulations. So we are by default dealing with a population that has medical need, and thereby training would be critically important, I think, to be able to really ensure consumer protection as we move forward. And I'm sure, again, that we have within our stakeholder and industry participants a lot of training that's already gone on. And so finding out what has already been established could be extremely helpful to educate and inform us in terms of what is needed. Thank you very much to our panel. I appreciate your participation today.
Thank you very much.
Thank you. With that, we'll be moving on to our local perspective. We have 4 panelists who will be speaking from their perspective of what they see in their cities, in their police departments, and in their counties. Thank you so much for joining us today. We'll begin with our first panelist, Sarah Carrillo, Tuolumne County Council. Thank you for being here today.
Good afternoon, Chair Bonilla, Dodd, Bonta, committee members. I'm Sarah Carrillo, County Council for Tuolumne County. I thank you for the opportunity to address your committees regarding this matter. I would like to share Tuolumne County's experience with you. The county does not have an ordinance on the books related to cultivation or distribution. However, under the principles of permissive zoning, it's banned in our county. So obviously the county has a lot of work ahead of it in order to respond to the Medical Marijuana Regulation and Safety Act. During the last several years, the board had contemplated a proposed ordinance. There was much speculation that any type of legislation would come from a ballot initiative, so the board elected to wait to see if that occurred. And when the board learned of the passage of this act, it came as quite a surprise. I think everybody really thought that that would happen through a ballot measure on the November election. County staff and the board have worked with their various statewide affiliates, such as RCRC, CSAC, County Council Association, and others, to learn more about this new law and how to respond. The board considered the following options. 1 is just maintaining the status quo. 2 was an express ban codifying the status quo. And 3 was consideration of a regulatory framework. Obviously, there was a lot of urgency to this issue, given that the law would go into effect just 2 months later. After protracted discussions with a variety of county departments, including our district attorney, our sheriff, fire, code compliance, as well as from constituents on both sides of the aisle, the board directed staff to draft an interim ordinance to allow small-scale personal cultivation. The board does not hold a unanimous position on this topic, and during the board meeting, the various concerns were expressed by the board members. All are concerned about the criminal element that can be associated with this industry. On the minds of the members included the October 2015 shootings in our neighboring county related to alleged theft of marijuana plants, resulting in 3 deaths. Board members were also concerned about children having access to marijuana and even cited to a 2014 incident involving 3rd graders at a local elementary school caught smoking marijuana in their school bathroom. Additionally, environmental concerns are part of the board's discussion. In Tuolumne County, we have seen illegal cultivation impact the environment. That includes illegal grading of land, water theft and diversion, illegal campsites with garbage and sewage not properly stored. Financial resources are necessary to address the cleanup of these sites, and a portion of any state tax should be directed to local jurisdictions to help address this issue. One area of agreement amongst all of the board members is their understanding that patients should have access to medical marijuana when it's necessary. So that's why they agree that small personal grows are acceptable, and they also decided they did not want to take an action to ban mobile deliveries. The board directed staff to form a working group to address medical marijuana in more detailed regulations. So that's going to include supervisors, patients, caregivers, doctor, concerned neighbors, kind of the whole group of people interested in this topic. But work won't begin until May or June. The board really wants to see if there's going to be a ballot measure related to the recreational use of marijuana. It would like to combine efforts if that's going to come to fruition. So ultimately, the board sent a proposed ordinance to allow small-scale personal cultivation of up to 12 plants to our Planning Commission, and that hearing will be held tomorrow. One of the primary concerns that our board has been discussing is enforcement. In Tuolumne County, there is no separate code compliance office. Our chief building official is our code compliance officer. Staff and the board expressed concern about building inspectors, environmental health officers, agricultural commissioners enforcing laws related to medical marijuana because of some of the illegal activities that can be associated with cultivation and distribution. Further, building inspectors or code enforcement officers are not trained or familiarized with marijuana cultivation and distribution, such as a narcotics officer or someone in the industry. So it's really important that any type of regulatory and enforcement scheme include the fact that training is absolutely necessary for these people to be able to do their jobs. And that, of course, includes not just the training opportunities, but financial resources to local jurisdictions to ensure that that happens. So in terms of the county's proposed ordinance, the board eventually decided that code compliance would take the lead. There was a lot of discussion with our sheriff's office kind of being resistant or reluctant to want to be involved just because of the past discrepancy between criminal law and civil law. So at times, because this issue has ever evolved, law enforcement's found itself in a really uncertain legal arena. So law enforcement will be part of this task force just to ensure that their safety issues are addressed and provide any technical assistance that they can. We believe the law is relatively clear on what our respective rules are. What's not clear is how counties will work with our various state agencies. So we will not know really what our role is until we see the regulations that will come from the state agencies, especially Department of Food and Ag. The lack of clarity in the regulatory process is probably one of our biggest obstacles facing counties, and in the ideal world, this law would not have become effective for at least 1 year after the regulations were adopted. That would give local jurisdictions the time to draft regulations in a thoughtful manner. There's a lot of questions that are unanswered. What will enforcement look like? What role will state agencies play in that? And how active will the state be in terms of enforcement? There has been a concern that municipalities have been rushing into bans, and of course the question is why? Because absent the lack of clarity, particularly at the regulatory level, bans are easy. They maintain the status quo. They allow time to construct local regulatory schemes that stakeholders feel comfortable with. And the bottom line is it's easier to undo a ban than it is to create a well thought out regulatory scheme, especially when you're considering the short time frame. The committees have expressed an interest in knowing if counties have been working with parties from the medical marijuana industry. I would say yes. In Tuolumne County, our board did create the medical marijuana working group. I understand that industry folks have applied to be part of this working group, and that's likely to have members on it when those are appointed. And in closing, I've been asked what can the state do to help, and I would say 4 things. First, develop regulations sooner rather than later and work with local governments in that construction. 2, eliminate the C4 clause related to the March 1st deadline as soon as possible. 3, integrate CDFA's EIR process with that of cities and counties and give cities and counties the ability to piggyback on it. Local jurisdictions are often faced with CEQA challenges. The financial impact from any sort of litigation falls solely on that jurisdiction when it develops its own regulations. So any action the state can take to help lessen this impact would be greatly beneficial. 3rd, enact a statewide cultivation tax to address environmental impacts of cultivation. And then lastly, ensure that local jurisdictions have the tools to make the solution fit for each jurisdiction. We are all different, and we should have the ability to create a regulatory and enforcement scheme that works for our community. Thank you for allowing me this opportunity to share Tuolumne County's experience, and I'm happy to answer any questions you may have.
Thank you so much. Just before we move on, I wanted to make the announcement that we have prepared additional copies of the agenda and the background paper, which are out in the hallway, and we wanted to make sure the public knew those were available for them. We'll now move on to our second speaker, representing the League of California Cities, Tim Cromartie. Welcome.
Madam Chair, thank you. Chair Bonilla, Chair Dodd, Chair Bonta, members. Thank you for the opportunity to address you on this important topic of implementation. I will follow the outline provided by Mr. Bonta's staff in terms of my remarks. Some of the biggest obstacles we see with regard to establishing this new regulatory scheme are, one, frankly, fending off efforts to materially alter the regulatory structure before it becomes operational. It's going to be challenging enough for state government officials and their staff to get their hands around the regulatory task in front of them without it being a moving target. On that note, we would respectfully caution against creating new categories of licensure, because it is clear in the legislation enacted last year that the relevant agencies that are going to be issuing the licenses are free to do that if they see the need. That should be left up to the regulatory bodies. Next, it will be necessary to help state agency staff get up to speed so that they are confident as they approach their regulatory duties. And to that end, to pick up a previous comment by Dr. Wood, it may be beneficial for the state to consider investing in what are most likely going to be privately sponsored training programs. And the city of Oakland has probably led the pack in undertaking this task successfully. In terms of enforcement, that is a key issue for the league, because cities, when they considered medical marijuana regulation, were very anxious about who would handle the enforcement, which is why we are very pleased with the dual licensing protocol that has been established by state legislation, and the fact that it allows for, up to a degree, dual enforcement. Effective enforcement will need to be a partnership between state and local government. Given the state's finite resources, we expect its focus will be on licensing and developing appropriate regulations. A good deal of the enforcement will be at the local level, at least initially, and will focus on local permitting and land use requirements unless locals request and relevant state agency grants the ability to enforce state law at the local level as provided for in the legislation. In terms of what local governments are doing to prepare for this new regulatory scheme, local governments have been overwhelmingly focused on the March 1st deadline on cultivation ordinances that was imposed in AB 243. We want to take this opportunity to publicly thank Dr. Wood for promptly stepping forth with cleanup legislation to remove that deadline. The focus and the reason locals have been so anxious about that is they don't want to necessarily be preempted by the state. Regardless of where they are on medical marijuana regulation, there's a common thread in most cities, and that is that they want to be able to set the rules themselves. And that's true whether it's Oakland or the city of Riverside, which at one point was the poster child for bans. Our messaging has been designed to have, because we got a lot of questions on this still, designed to have our members retain their local regulatory authority under any and all scenarios. In recognition of the fact that AB 21 is moving, we have supported that legislation. We have educated our members on the fact that that cleanup is pending, but as often happens in the legislative process, very often things go sideways. In this case, there was a demand on the part of the American Civil Liberties Union, Drug Policy Alliance, and others to have a patient access amendment added to that bill. We ran into some difficulty, but as of this weekend, we have a deal that we believe will allow that legislation to move forward quickly and expeditiously. So we're looking forward to that, but that development did seem as though it might derail AB 21 for a time. That is why we have been so cautious about advising our members to put bans in place. That was controversial, we know, but in developing that messaging, we consulted with our legal counsel. Our legal division was of the opinion that locals had only until March 1st. It is very time-consuming process to develop a comprehensive, well-thought-out cultivation ordinance. You need time for community input, which may mean multiple council meetings where there's an opportunity for public comment. You need to have your staff do the research, particularly if they are not up to speed on this policy area and have no clue, perhaps, how to regulate marijuana cultivation. That takes time. And finally, cities have got to have time to have their city attorneys vet whatever proposal the staff comes up with. All of that does not happen on a short window. And the concern many cities have had is that they simply would miss the deadline and be preempted by the state, particularly if something happened with the cleanup bill, AB 21. To that end, a lot of them have rushed forward to put bans in place. In a number of jurisdictions, those bans are going to be temporary. Two classic examples are Grass Valley and, in particular, the city of Eureka up in Humboldt County. Now, marijuana cultivation is extremely important to the local economy up there, so I think we can all be certain that Eureka's ban, which is in effect today, is not going to be permanent. They are definitely moving forward with preparations for a comprehensive cultivation ordinance, but they were concerned about the March 1st deadline. In terms of costs, I've cited one of them. State agencies are going to incur significant costs in developing regulations governing their respective areas of responsibility. There will be a need to hire new staff. Local and state governments may also both incur significant expense in hiring consulting firms for help with the implementation. A number of cities we know are doing that. We're getting anecdotal evidence that cities are contracting with private firms for assistance. In terms of what we've been doing specifically to educate our members on the new legislation, we have held 2 webinars and planned 7 with a possible 8th informational briefing at various locales around the state to have them see us. We have developed a PowerPoint presentation, and we've updated it periodically. We're keeping members up to speed on the developments with AB 21. And we've been very clear that locals need to continue to make preparations just to avoid preemption, just in case anything in the near future, goes sideways with AB 21. At the moment, we do not expect that, and there is every reason to believe that the bill may move forward with bipartisan support and may retain its current 2/3 status. In terms of, we often get questions on how many cities are working on ordinance, how many cities have banned. We do not have comprehensive information on this. Our information is anecdotal because cities are not required by law to report to the league on what they're doing. We are keeping track as best we can. Our information as of January 14th is that 53 cities have enacted ordinances and 26 more have agendized a proposed ordinance for upcoming city council meetings. In terms of how many cities have implemented bans versus allowing regulation, we don't know for certain. Probably a majority of the 53 cities have enacted bans, some of which are clearly temporary. Alameda County's ordinance, for example, by its own terms, lifts the ban upon the appeal of the March 1st deadline. But 2 other cities I cited previously, Grass Valley and Eureka, have definitely made clear that their bans are going to be temporary. In terms of working with industry, cities have been doing this to the degree they are inclined and have the resources to finance it. Again, Oakland has set a precedent in doing this years ago. Our feedback in general on the new legislation is let's get it implemented before we try to restructure it. Defer to the relevant agencies in terms of much of the fine-tuning that needs to happen. I think our view is that the legislature should fix what are the major problems that we can identify now and leave the rest to the regulatory agencies. And again, the development of ordinances takes time. You heard a previous speaker say that it is easier to repeal a ban than to enact a comprehensive, functional, well-thought-out ordinance. I would add to that it is also easier to enact a ban than to rush and put a hastily worded ordinance in place that is not functional and may lead to litigation, and to try to undo that mess rather than take your time, do it right, and put a ban in the meantime as a placeholder regulation for purposes of passing the litmus test to avoid state preemption. Thank you for your attention. I will be happy to answer any questions.